Privacy law is the practice area where the rules change fastest, vary most by jurisdiction, and carry the largest penalties for getting it wrong. A data processing arrangement that is lawful in one jurisdiction and unlawful across a border. A breach notification clock that starts at 72 hours in one regime and immediately in another. A cross-border data transfer that was fine last year and is now exposed because the legal basis underneath it has shifted. Privacy Counsel live in a landscape where the ground moves under them constantly, and the cost of falling behind is measured in regulatory fines that reach into the percentage of global revenue range. Privacy Legal in the Claude for Legal release is the plugin built for the practice area most defined by cross-border regulatory complexity. Data mapping, transfer impact assessment, breach response, and privacy policy maintenance. Each one is a workflow where the law is fragmented across dozens of jurisdictions. Interpretations shift constantly, and the Privacy Counsel is the person responsible for holding the whole moving picture in their head. The panel's view from the launch materials is that Privacy Legal is the plugin where the jurisdictional anchoring from the broader Claude for Legal architecture does the most work, because privacy is the practice area where the same factual arrangement produces the most divergent answers across borders. This episode walks through the 4 named workflows, the configuration that calibrates the plugin to your regulatory footprint, the insight that distinguishes how the plugin changes privacy practice, and the strategic implication for the privacy function over the medium term. One integrity note before the walkthrough begins. The panel has not yet deployed Privacy Legal on a live matter. The analysis here is built from the launch documentation, the GitHub repository, and the panel's collective privacy practice experience. The deployment report comes in a later episode, once 30 days of real matter use have built up the evidence base. Privacy Legal opens with a configuration that is built around the regulatory map. Where the other plugins ask about your practice and your playbook, Privacy Legal leads with jurisdiction, because in privacy, the jurisdiction is the practice. 15 to 20 minutes of setup, 4 sections. The first section asks about your regulatory footprint. Which privacy regimes apply to your organization or your clients? The European framework, the California framework, the other state frameworks, the sectoral regimes, the emerging regimes in jurisdictions where your data flows. The plugin uses this to set which bodies of law it applies to every analysis and which interactions between regimes it watches for. The second section asks about your data landscape. What categories of personal data your organization processes, where it is collected, where it is stored, where it flows. The processors and subprocessors in the chain. The plugin uses this to build the data map that the other workflows reference. The third section asks about your standard positions, your organization's risk tolerance on transfers, your standard contractual protections, your breach response thresholds and escalation paths. The plugin uses this to calibrate its recommendations to your organization's actual posture, rather than producing generic privacy advice. The fourth section asks about your active matters, the data processing arrangements under review, the transfers being assessed, the breaches under investigation, the policy updates underway. The plugin uses this to build the matter file. As with the other plugins, this section compounds. The plugin gets materially sharper on your specific regulatory landscape as more matters flow through it. The panel walks through each workflow with the same 3 questions. What does it do? Where is the gain most visible? And where do the gaps show up? The 4 workflows are data mapping, transfer impact assessment, breach response, and privacy policy maintenance. Each one targets a different part of the privacy function, and the 4 together cover the core of what in-house Privacy Counsel and external privacy advisors do across a typical quarter. Data mapping is the foundational workflow because every other privacy analysis depends on knowing what data the organization holds and where it flows. Transfer impact assessment is the workflow that runs whenever data crosses a border, which in a modern organization is constantly. Breach response is the high-pressure workflow that runs on a regulatory clock when something goes wrong. Privacy policy maintenance is the continuous workflow of keeping the organization's external and internal privacy documents current with a legal landscape that does not stop moving. The four workflows compose: the data map feeds the transfer impact assessment. The transfer analysis feeds the breach response scoping when a breach touches cross-border data. The whole picture feeds the policy maintenance. The plugin holds the regulatory map and the data map across all four workflows. Data mapping is the workflow that everything else depends on, and the one most organizations do badly because it is tedious, it goes stale the moment it is finished, and it requires pulling information from every corner of the business. What personal data does the organization collect? From whom? For what purpose? Where is it stored? Who has access? Where does it flow internally and externally? Which processors touch it? How long is it retained? The Privacy Council, who does not have a current data map, is doing every other privacy analysis on incomplete information. The plugin reads the organization's systems documentation, data processing agreements, vendor contracts, and prior data mapping work and produces a structured data map. Categories of data, sources, purposes, storage locations, access, flows, processors, retention. The output is the living document privacy teams have always wanted and rarely maintained because the manual version goes stale faster than a team can keep it current. The gain is that the data map becomes maintainable. The traditional data mapping exercise is a quarterly or annual project that consumes weeks and is out of date by the time it is finished. The plugin makes it a living document that updates as the underlying contracts and systems change. The Privacy Council moves from periodically reconstructing the map to continuously maintaining it, which is the difference between privacy compliance that is real and privacy compliance that is theater. The gaps come from data the documentation does not capture. Shadow IT, informal data flows, the spreadsheet a team built that processes personal data outside the systems the plugin can see. The plugin maps what the documentation shows. The Privacy Council still has to know the organization well enough to find the data flows that no document records, and those undocumented flows are frequently where the real risk lives. Transfer impact assessment is the workflow that runs every time personal data crosses a border, which, in a cloud-based organization, is continuously and often invisibly. Every transfer needs a lawful basis, an assessment of the destination jurisdiction's legal regime, an evaluation of whether the transfer mechanism holds up, and supplementary measures where the base mechanism is not enough. The analysis is genuinely hard. It changes as the law evolves, and getting it wrong exposes the organization to enforcement in every jurisdiction the data touches. The plugin reads the transfer arrangement, the data categories involved, the source and destination jurisdictions, and the transfer mechanism in place. It produces a transfer impact assessment with the lawful basis analyzed, the destination regime evaluated, the mechanism tested, and supplementary measures recommended where the base mechanism is insufficient. The output is structured, way a regulator would expect to see the analysis documented, which matters because the assessment is only as valuable as its defensibility under scrutiny. The gain is that transfer assessments become feasible at the scale modern data flows actually require. The traditional transfer impact assessment is so labor-intensive that organizations either do them for the largest transfers and ignore the rest, or do them once and never revisit them as the law changes. The plugin makes it feasible to assess transfers at the scale they occur and to revisit them as the legal basis underneath them shifts. The gaps come from the jurisdictions where the law is most unsettled. The plugin handles the major regimes and the established transfer mechanisms well. It handles the emerging regimes, the jurisdictions with rapidly evolving law, and the genuinely novel transfer structures less reliably. And those are precisely the situations where the Privacy Council's judgment about regulatory risk tolerance matters most. Breach response is the workflow that runs on a regulatory clock under pressure with incomplete information at the worst possible time. A breach is discovered. The notification clocks start, and they run differently in every jurisdiction the affected data touches. The Privacy Council has to scope the breach, determine which regulators must be notified and by when, determine whether affected individuals must be notified, draft the notifications, and do all of it while the facts are still emerging and the business is in crisis mode. The plugin reads the breach facts as they develop, the data map, and the applicable regulatory regimes, and produces a breach response plan. Which jurisdictions are implicated? Which notification clocks are running and when each one expires? Whether the thresholds for regulator notification and individual notification are met in each regime. Draft notifications calibrated to each regulator's requirements. The plan updates as the facts develop, which matters because breach facts always develop. The gain is that the breach response timeline becomes manageable under pressure. The hardest part of breach response is holding the multi-jurisdictional notification matrix in your head while the facts are still moving and the clock is running. The plugin holds the matrix. The Privacy Council makes the judgment calls about scoping and materiality, which is where their expertise actually matters, rather than spending the critical early hours reconstructing which clock is running in which jurisdiction. The gaps come from the judgment calls at the center of every breach. Whether an incident is a notifiable breach at all. Whether the risk to individuals crosses the threshold. Whether to notify proactively beyond the strict legal requirement for reputational reasons. The plugin scopes the requirements. The materiality judgments and the strategic notification decisions remain the Council's, made under pressure with consequences. Privacy policy maintenance is the continuous workflow of keeping the organization's privacy documents current with a legal landscape that changes constantly. External privacy notices, internal data handling policies, cookie policies, consent mechanisms, records of processing, data protection impact assessments. Each one has to stay current with every regime the organization operates under, and each regime changes on its own schedule. The traditional pattern is that privacy policies get updated reactively when a regulator asks or a complaint surfaces, which means they are usually behind. The plugin reads the organization's current privacy documents, monitors against the regulatory regimes in the configuration, identifies where documents have fallen out of compliance, and produces a prioritized update list with drafted revisions. The Privacy Council reviews the list, decides what to update and in what order, and reviews the drafts the way they would review a junior's work. The gain is the same structural shift the panel keeps returning to across the Claude for Legal plugins. The work moves from reactive to continuous. The privacy documents stay current as the law changes, rather than falling behind until something forces an update. The Council's attention concentrates on the policy decisions that require judgment, rather than the mechanical work of tracking which regime changed what. The gaps come from policy positions that encode business decisions rather than legal requirements. How aggressively to collect data. How to balance user experience against consent friction. How to position the organization's privacy posture relative to competitors. The plugin keeps the legal framework current. The business judgment dimensions of privacy policy remain with the Council and the business. I know what you are thinking. You are thinking that privacy law changes so fast that a model trained on data with a cutoff date is exactly the wrong tool, because it will confidently apply last year's law to this year's question. And in privacy, last year's law is a liability. That concern is not just reasonable. It is the single most important thing to understand about using any AI tool in privacy practice. The answer is that the plugin's value is not in knowing the current law from training. Its value is in holding the structure of the analysis while you supply the current law. The transfer impact assessment framework does not change when the law changes. The breach notification matrix structure does not change. The data mapping schema does not change. What changes is the specific content that goes into each cell, and the plugin is built to take the current legal position as an input rather than to supply it from training. When the law shifts, you update the regulatory configuration, and the connector layer pulls the current sources, and the plugin applies the new law to the same structural analysis. This is the inversion that Privacy Counsel need to understand. Do not use the plugin as a source of what the law currently is. Use it as the engine that applies whatever the current law is to your specific facts at the scale your data flows require. The currency of the law is your responsibility and the connector layers. The structure of the analysis, held consistently across hundreds of transfers and dozens of jurisdictions, is what the plugin contributes. Get that division right and the plugin is powerful. Get it wrong and trust the plugin for the current law, and it is exactly the liability you feared. The Privacy Legal plugin handles cross-border complexity with sophisticated jurisdictional intelligence. But the durable verification skills from the Foundations series apply in full, and the jurisdictional discipline matters more in privacy than anywhere else in the Claude for Legal release. Verify every citation from Foundations number 6 applies to every regulatory provision and every enforcement decision the plugin cites. Privacy analysis turns on specific articles, specific recitals, specific enforcement actions, and a misstated provision is a defective assessment. Run the verification on every regulatory citation that carries weight. The 5 Qs protocol from Foundations number 7 does its heaviest work here. The jurisdiction anchoring Q is the difference between a transfer assessment grounded in the correct regime and one that confidently applies the wrong jurisdiction's standard. In privacy, the wrong jurisdiction failure mode is not a minor error. It is the whole ballgame. Anchor every analysis to the specific regime, the specific version of the law, and the specific date. Build a chronology in an afternoon from Foundations number 5 applies to breach response, where the sequence of who knew what when determines the notification obligations and the regulatory exposure. The chronology methodology is how the breach timeline gets constructed quickly enough to meet the notification clocks. Step back from the 4 workflows and consider what Privacy Legal does to the privacy function over the medium term, because privacy is the practice area where the plugin's arrival changes the economics most sharply. Privacy compliance has been caught for years between what the law requires and what organizations can actually resource. The law requires data maps that are current, transfer assessments at scale, breach response across every jurisdiction, and policies that stay aligned with constantly changing regimes. Most privacy teams cannot resource all of that, so they triage, and the gap between what compliance requires and what gets done is where regulatory risk accumulates. The plugin narrows that gap. The work that was impossible to do at scale becomes feasible, which means the compliance posture can move closer to what the law actually requires, rather than what the team could previously manage. This changes what Privacy Counsel are for. When the plugin handles the production work of mapping, assessing, and drafting, The Privacy Council's role concentrates on the judgment calls, the regulatory relationships, the strategic decisions about risk tolerance, and the genuinely novel questions the plugin cannot resolve. The privacy function becomes more strategic and less administrative, which is where Senior Privacy Counsel have always wanted it to be and rarely had the capacity to take it. For senior privacy practitioners with the seniority and the context to deploy the plugin well, this is the most material change to privacy practice since the major regimes came into force. The work that drowns privacy teams becomes manageable. The judgment that justifies Senior Privacy Counsel becomes the center of the role. The practitioners who recognize the shift early are the ones who will define how the privacy function works for the next decade. That was the walkthrough. The 4 named workflows in the Privacy Legal plugin, the regulatory configuration that calibrates it to your footprint, the insight that distinguishes how the plugin changes privacy practice from how the launch marketing describes it, and the strategic implication for the privacy function over the medium term. The deployment report comes in a later episode, once 30 days of real matter use have built up the evidence base. The panel expects the transfer impact assessment workflow to be where the gap between the launch promise and the practice reality shows up most, because that is the workflow most exposed to the fastest moving law. The unpacked launch arc is nearly complete. Episode number 9 covers product legal and AI governance legal as a paired episode, the 2 plugins most concerned with the products an organization builds rather than the matters it handles. The arc closes with episode number 10 on the document layer connectors, iManage, NetDocuments, and Everlaw, the integrations that connect Claude to the document systems law firms already run on. If your practice touches privacy in any meaningful way, the Privacy Legal plugin is built for the exact complexity that defines your work. Adopt it carefully. Build the regulatory configuration with precision, because in privacy, the configuration is the practice. Keep the current law as your responsibility, and the plugin's structure as its contribution. The lane is moving fast, and the firms that move with discipline now are the ones that will be best positioned when the dust settles. That's the episode. See you in the next one.